challenge that it presents to courts that are confronting the foreclosure crisis and some of the attendant difficulties within their courts. We have, I think, all read the newspapers. We've all heard about the massive increase in filings of foreclosures that has occurred in the last several years. It's hard to know at this point, chicken and egg, whether the economic crisis that we are looking at was caused by the foreclosure crisis or vice versa, but we all know that filings increase sometimes tenfold, sometimes more in many jurisdictions, and for those of us jurisdictions where the foreclosures are actually handled directly by the courts, that increase in workload was tremendous. And I think many of us who are court managers were really concerned mainly by this incredible increase in volume in a very short time, during a time where we all were facing resource cuts rather than increases to deal with this additional workload. At a time where the question was, how do we accommodate this, and how do we continue to be able to resolve these cases in an appropriate and timely manner? We were facing, I think in many jurisdictions, furloughs, outright layoffs, and other restrictions in resources. And so for many of us, the focus became on how do we realign resources within the courts to be able just to address filings that were threatening literally physically to overwhelm us. Then I think last fall, all of us became aware of possibly a greater threat to the courts, and that was that many of the filings seemed to have problems, and problems that were not necessarily apparent on their face. Problems with signatures not being valid signatures, even where the people who were actually the signatories signing them, they were not doing the due diligence and the sorts of review that was required to ensure that what was being filed with the court was actually something that the court rely upon and have the level of integrity that courts have expected. I think it came as a shock to many of us that affidavits, those things that those of us who are lawyers know are kind of the wonderful aspect of the work that we do, and that is we can swear to something and the court can rely upon it, our oath and our veracity, and our having investigated and done the due diligence to allow the court to rely on this. So we realized that we had within many of our jurisdictions, in essence, a pretty corrupted caseload, and we needed to figure out how to go about dealing with regaining the integrity, reaching out and figuring out how to put into place the various mechanisms and case management initiatives to get control back over these caseloads so that some of the very functions that courts are supposed to be able to provide, the things that make members of the public have faith in the ability of courts to do justice, could actually be addressed. Today we have with us, to my left, Mary Lee Castellanos. She is manager of the foreclosure project for the 11th Judicial Circuit, that's Miami-Dade County in Florida. She has dealt with some 82,000 foreclosure cases. Her esteemed colleague is Judge Jennifer Bailey. She is the civil administrative judge for the 11th Judicial Circuit, that again is Miami-Dade County. She is the chair, or was the chair, of the Florida Supreme Court's Residential Mortgage Foreclosure Task Force. She is the author of a foreclosure bench book that was put together for judges in Florida. She also has been vice chair of the Education Committee for the Courts of Florida. She will be speaking about the initiatives that they have undertaken to try to address the foreclosure crisis in Florida and their impact on the courts. Next to her is Deputy Attorney General John Kelleher. He is from another state heavily hit by foreclosures, and that's Nevada here. He is the head of the Criminal Justice Fraud Unit. He's also the head of the Nevada Attorney General's Mortgage Fraud Strike Force. With him is Todd Gross. He's an investigator who can tell you about some of the things that they're encountering, and we plan to have presentations by each of them to tell you what their viewpoint is in terms of what courts can do and how courts are being affected, and then there'll be time at the end for questions. So please do realize that there is time for that. Why don't we get started with John?
Good afternoon, everyone. I guess my job is to discuss the kind of the table setting here for the crisis we're facing, and put things a little bit in context. In our office, our Attorney General created our Mortgage Fraud Strike Force in 2007, which was fairly quickly in comparison to a lot of other jurisdictions. I think Florida and Nevada started facing the problems faster than the other states, and obviously the need to address it came quicker. From a criminal context, I was picked to head up this task force, I think in large part because prior to this I was a securities fraud prosecutor for the state, and there was no precedent for mortgage fraud at the time our task force was created, so our unit literally had to invent the wheel. And we did that by partnering with other jurisdictions, looking at what other states were doing. But it quickly became apparent that this wasn't just a local issue, it was a national issue. And in the criminal context, sadly I hate to say, but it's conspiracy and organized crime. We originally started dealing with fraud in the origination of the loans. That was fraudulent document creation, people overinflating income. It wasn't just the homeowners doing it, it was the brokers, it was everybody, anybody that could make money had a motive. And there was a lot of money to be made during the bubble, as you all know. After that, when the foreclosure started, there was a cottage industry created for foreclosure rescue. That was the next wave of fraud that we saw. A lot of people coming in, setting up these overnight companies and promising, for $3, $5, $7, $15,000, they'll guarantee you they'll get you a loan mod. Many times they just took the money and ran, and that created an inroad for organized crime because it became a very lucrative and very easy way to launder money. You set up these companies with barely any regulation, at least in the beginning. Once the states started regulating, they just put straw owners in for them, but it was still the same group of people pulling the strings. Now we've come full circle where now we're in the foreclosure process and we're seeing fraud from top to bottom again. Same type of, the common denominator in all of these is fabrication, creation of false documents. It started in part because of the complicated securitization of the loans that began and I think was one of the main reasons we have this crisis now. They were literally taking MIT engineering students and hiring them on Wall Street firms to come up with these complicated investment schemes, and a lot of times they didn't dot the I's, cross the T's. They were in such a rush to get these loans packaged and thrown into these security investments that they didn't meet the legal requirements for creating the securities. If you think of the security as a box, and you have a closing deadline to put the investment, the mortgages in the box. Well, a lot of times they didn't meet that. They never either didn't put it in the box or they put it in the box after the deadline, making the investment illegal. And none of this was ever disclosed to the investors. So there's securities fraud on the top level. How that affects us now with the foreclosures, though, is because a lot of the documents were never transferred originally when they were set up as a securitized loans. The banks and servicers now are having either difficulty, inability, or it's impossible to find the original loan docs. So what we're seeing locally and nationally is, in many instances, they just create them. There's two reasons. In some instances, they don't exist, but I think in more instances, they do exist, but I think they've done a cost-benefit analysis, and kind of like the famous Pinto case, it's actually cheaper for them to create the fraudulent documents and hope no one catches them than to spend the money and time it takes to obtain the original documents. And that is where we're at as far as context. The types of cases we're dealing with, we've seen on a routine basis now involve organized crime, drug cartels, we've guns, prostitution, human trafficking. It's across the board, any type of criminal activity that you can think of in the organized crime, the traditional mafia type crime, we've seen in connection with these companies because it's very lucrative. A lot of these are cash businesses. They're easy to set up. They're easy to close down. As soon as we prosecute one, they pop up down the street under a different name, different person, but it's still the same organized crime entity running it. So it's a monumental job investigating these. Some of you may have heard of the robo-signing. We've seen cases where you basically have a guy being paid minimum wage or $10 an hour to sit there and just sign documents all day as the president of various companies or notarize signatures all day. Todd can speak a little bit more specific on that issue. Notary fraud, securities fraud. In the end, we're talking about illegal foreclosures and fraud on the court. And one of our main roles here is not to prevent a legal foreclosure from going through. If parties have the right to foreclose, they're entitled to under the law. If the homeowner isn't paying, then the foreclosure is absolutely proper. The process but the process has to remain. The integrity of the process has to be preserved, and that's what we're trying to address. At the end of the day, an attorney, a firm, no one should be filing anything, whether it's a foreclosure or a civil complaint of any type, using fraudulent documents, because that undermines the integrity of our judicial system, and ultimately it'll undermine home ownership and foreclosure, because we'll have title issues down the road if an improper party was permitted to foreclose and then sold, and that's ultimately going to affect our ability to recover from the financial problems we're having. I have a short video here. It's prepared by Emily Wills. She's a forensic document examiner, and it basically takes you through how easy it is to create these fabricated documents and how professional looking they are. When we first started doing these cases 3-4 years ago, we would do a search warrant and we would find signatures scotch taped under the desk. They'd have multiple people's names. That was the low-tech version. What you're going to see on the video is currently what they're doing. Very high-tech, very savvy, but you don't have to be a computer whiz to do this. Anybody that can basically use Photoshop or one of those programs can do this. So I'll play this for you. It's only a few minutes long.
With a pen.
No picture.
That document is...
Yes. Apologize, this happened last night too. We have to... I think if it sits too long, the picture goes away.
Freezes.
And you'll see on the video the quality of these forgeries and fabrications are so good. Unless you really know what to look for, it's almost impossible to tell that these documents have been fabricated. And that's part of the problem. Homeowners don't know. Even attorneys representing the lenders sometimes don't know. We're talking about very sophisticated forgeries.
When a person signs a document with a pen, that document is an original document. The inked signature cannot be moved to any other document. However, it is possible to use a scanner, computer, and printer or copier to manufacture an entirely new document. The signature would be a duplication of the original signature, but it would not be written with ink and would not prove the individual's acceptance of the document. The only way to be sure that a signature is intentionally attached to any disputed document is to examine the original. Let's take a look at how computer software, such as Photoshop, can be used to manufacture a document which might fool even an attorney or judge who did not realize the importance of original documents and how to recognize them. High-resolution scans of original documents are the source for elements that can be reconfigured to create new documents. Any portion of a scanned document can be selected and saved to be used as a building block for a new document. This is a visual catalog of all of the building blocks I have captured and saved. The next step is to inspect and clean up our building blocks. In this registration seal, I want to erase the smudges of blue in the background. I'll also erase the black 3. Let's change the date of the stamp. The blue arrow points to the date on the red perimeter ring. So I can change the date by rotating either the date ring or the arrow. I've isolated the date ring on a separate layer, so I can spin just that layer to indicate whatever date I choose. Using the same technique, I could also rotate the blue layer. Next, let's change the year. An easy change would be from 2010 to 2011. What makes this easy is that I can remove the 0, duplicate the 1, move it into position, and thereby avoid having to create a digit from scratch. This Washington Mutual stamp, including the Cynthia Riley signature, has lines running through it that we do not want, so let's get rid of them. If a mistake is made, no problem. The undo, redo commands are two of the best features of most computer software. Now we have removed the unwanted lines. The stamp is not perfectly horizontal. This is fine for a stamp, but for the purpose of demonstration, let's say we want it to be exactly horizontal. It is possible to make the image rotate into the exact position desired. This stamp now becomes a good building block for creating a new document. I've shown you as many techniques as I can in a brief video. Now, let's quickly manufacture a fake document. I'm starting with an assignment that I created following the pattern of a real assignment from my files. For this demonstration, I've used names that mesh with the elements I have on hand. All I have to do is drag in each of the elements I want to use, and then resize the element. For the clerk's filing stamp, I will also rotate it a bit to give it a more authentic, not so perfect appearance. Next, import the image of the attorney's rubber stamp. The handwritten date has to overlap the text of the document, so it has been saved with a transparent background. This way, the new element blends seamlessly into the document. Next, let's add the signature of the witness and then the signature of the notary public. Of course, the notarization is not complete without the notary seal. The final building block to add to this fake document is the Washington Mutual stamp, which includes the signatures of Margaret Dalton and David Arnold. Our fake document is complete. I don't know how often fake documents might be presented in litigation, but what I hope you will gain from watching this video is a greater respect for the importance of original documents.
So as you can see from the video, it took less than 5 minutes to create a fraudulent document. So you're looking at motive. Why would a bank risk this? Why would they do this? Many times we're told it takes anywhere, upwards of 90 days or more to obtain the original documents from the trustee for the investment, and there's also a lot of fees entailed. You could cost them $500 or $1,000 when it's all said and done. Meanwhile, they have to wait 3-4 months to do it. When you have the volume of cases that they're trying to turn over for foreclosures, they did a cost-benefit analysis, and doing that in 5 minutes is a lot cheaper. And because the forgeries are so sophisticated and so well done, statistically they haven't been caught. So from a business standpoint, you can see they're making more money doing this than they would doing it legally. Again, we've seen a wide breadth of criminal activity. The organized crime part sadly is becoming more of the norm than the oddity. We're seeing more and more overlap with traditional organized crime, the Russian mob, UK mob, the New York mob, drug cartels in Mexico, the LA gangs. It's a very fast, lucrative business. You can make money, cash. It's a very easy way to get your hands. You open up a loan mod company, you can get your hands on people's identifying documents and social security numbers. We worked a case involving one of the LA gangs where they had an overseas call center. They would take the information, they would create bogus social security cards, driver's licenses, birth certificates, go out and buy houses and cars, and then they ran their prostitution ring out of those. We did a search warrant on a company about 6 months ago, and they were running a loan modification business out of the front and a happy ending massage parlor in the back with an escort service attached. It's basically the loan mod company was a front for the other stuff. So these cases require the concerted effort and coordinated effort of the state, local police, federal agencies. We're seeing money transferred nationally, internationally, which is always beyond, it's beyond our jurisdiction, so we absolutely have to partner with the federal entities. And, we're talking hundreds of millions, and at least in one of our cases, billions of dollars that we've seen transferred through these companies. I'll let Todd speak a little bit to the specifics of what's entailed in our investigations. That's the thing. Our cases aren't like a police case where they go out and you have the criminal, you have the witness, and you have the weapon. A lot of times we have to, just obtaining the documents we need to determine what happened can take years. So, it's a large and complicated task, but I'll have Todd speak directly on that.
Well, as John said, as the technology is improving, it's making it much more harder to detect the good documents from the bad documents. And in these sort of cases, we have to look solely at the documents themselves. Just obtaining the documents has become quite a problem. We've had banks that have been very difficult in providing them. You can serve a subpoena on a bank. There was one bank in particular where I just simply had to send information to a bank in California, and that was going well for up to a period of time. I faxed over a subpoena to an attorney's office working for the bank, and I got a letter from somebody in Phoenix saying we aren't going to respond to that subpoena because it wasn't properly served. I asked how should I serve it then? They said just take it to any of our local branches. And they said from there then they will just simply fax it over to us. So they could fax it, but I couldn't. And it just showed me they're just simply playing games in a way to delay the process. And that was after waiting a full month from the time I had served the subpoena in the first place. And I'm still waiting for them to fulfill those document requests. And I've had this take up to 6 months in some cases. Looking at just the documents themselves, as John said, we had found where they would cut and paste literally pieces of paper with signatures onto documents, and that sufficed for a while, but now the process has become much more sophisticated. In the robo-signing cases, maybe you've seen in different news stories where Linda Green's name keeps coming up. What we were doing was just taking the documents that we did have and look for anything that was repetitive, and we are finding some names that just seem to pop up much more than others. Put the name into Google and to find, yeah, they are robo-signers. And they're self-admitted. There is deposition transcripts available online, videos of their depositions online. One individual, he claimed that he would do 2,000 to 4,000 documents a day. All he would do is just sit there with a pen all day and just write his name. And he admitted that he would sign on the behalf of over 20 different companies. Sometimes he was the vice president, sometimes he was assistant secretary, whatever the case may be. But the thing that I found to be the most outstanding about this, and the most hard to believe, was that he would sign one day as the vice president, and then the person at the desk immediately to the next to his was his notary. And then the next day it would just be reversed, where that person would be the vice president and he would be the notary. 2,000 to 4,000 documents a day that are using to foreclosure. It's going to clog the courts to the point that it's just bogging down the whole system. Recently, here in Las Vegas, we were looking through documents, and one name came up several times, and I found the individual. He admitted during an interview he had been working at a deli some time ago, and he ended up working with this company, and he was processing about 400 a day, in which that he would go onto their computer system, download the orders. Banks would just make orders for so many documents, for so many particulars, and they would produce the document. He was the notary. He would notarize the document, and then he would set it onto another desk for that individual to sign, but it may be sometime before that individual got to it, making the process completely backwards. Everybody knows, if you've ever had anything notarized, you sign the document, then you notarize the document. So these documents are being used to foreclose on people's homes. We've also looked at the information that you can find right within them, where the dates will be off drastically. The worst case scenario I have found is up to 6 months after the vice president signed the document, the notary signed the document up to 6 months later. We've also found where there's a variety in locale as well, where an individual in one state signed it, but the notary happened to be from another state, and it was being filed in a court in an entirely different state. So as this is an evolving sort of process, they're getting smarter, they're getting more sophisticated. We have to evolve along with them, and we can't, it's tough to get ahead of them. We have to see what they're doing next, so our investigations are ever evolving as well.
And the level of sophistication also hinders our ability to get and receive complaints, because a lot of times people can't tell whether or not the documents are fraudulent. So they may bring them into us and ask for professional analysis, but again, if you don't know specifically what to look for, there's really no way to tell just by naked eye a lot of times. Have there been foreclosures that have gone through using fraudulent documents? Absolutely. Is that the fault of the judicial system? No. Forever we've had a built-in reliance on the credibility and integrity of the banking system, the attorneys that work for the banks, and that integrity and that honesty seems to have gone out the window and been replaced with just unbridled greed. And Judge Bailey brought up a good point in the last session. Ultimately we're talking about the integrity of our system here. If people are permitted and able to perpetrate fraud on the court, it undermines the entire judicial system, the foreclosure process, and it's going to handicap our economic recovery. The long-term effects on the court are many. There's going to be, in the administrators, we're going to see an increase in, well, definitely in our state, an increase in criminal prosecutions. We're going to see an increase in filings of, well, hopefully fraudulent documents will curtail as we strengthen the prosecution efforts, but you're definitely going to see an increase in litigation over cases that are filed. Nevada has a non-judicial foreclosure state. Other states have a judicial foreclosure process. So it's a little bit more difficult to get our hands on the fraudulent documents as soon as we'd like to in Nevada. But they're out there, and we are obtaining them, but the process is slow. Administrators are going to see an increase in document requests from law firms, from law enforcement agencies, and ultimately, again, it's the fraud on the court that we're all trying to preserve, and the integrity of the actual foreclosure process for parties that are legally entitled to foreclose. With that, I'll pass it to Judge Bailey.
Good afternoon. My name's Jennifer Bailey. I'm the Chief Administrative Judge of the Civil Division in Miami-Dade County. Miami-Dade County is a large county. We're bigger than Rhode Island. We have 120 judges in our circuit alone. I am administratively charged with oversight of 26 in the Civil Division. I say administratively charged because you all are all court administrators and you know what that means. Trying to get judges to row all their oars in the same direction is like trying to teach Persian cats to swim. So I say that because it's interesting to talk to NACM because I'm sort of the bridge between the judges and administration. And as a result of that, I understand the challenges that you all face in terms of, first of all, trying to draw this to your judges' attention, although they all know about it. Everybody pretty much on the bench reads the paper. And secondly, to help them figure out what to do about it. Because at the end of the day, it falls on us. But as administrators, you're charged with supporting us in our efforts. And the big issue here is protecting the integrity of the court system. I mean, we hear euphemisms all day long about paperwork problems or document execution issues. I mean, look, if they're lies, they're lies. If you're filing a document that says, I saw John Smith sign this document and you're a notary, then, that's a lie if you didn't see him sign it. So one of the big issues for me is let's stop all these euphemisms and call it what it is. John is absolutely correct. For many years, foreclosures, frankly, were no-brainers. The banks that were foreclosing were the banks that originated the loan. They originated the loan with reasonable underwriting standards, and the bottom line is something bad or sad happened, and the borrower just couldn't pay it back and was going to lose their house. And as sad as that is, we're courts. Sad is our business. And so that credibility has attached to much of what started out in this crisis. The loan products got more exotic. You had subprimes with teaser rates and interest onlys and so on and so forth. And the way this really started, quite honestly, in 07 and 08 was these exotic loan products that started to reset into real loan terms. Then as we went into the 08, 09 and the Great Recession, you started to see people who were really, as opposed to changes in the loan terms, falling behind because of changes in their lives, loss of jobs, loss of hours, things like that. The big question is, how have we dealt with it? Let me give you the snapshot of Dade. Dade, like Nevada, we're sort of famous for being a particularly bad place in terms of both fraud and number of cases. In both states, you could describe us as sunny and underwater because very few houses in my community have held their value compared with the amount of debt that each house is carrying. My job, that I see it as administrative judge, is to help my judges, and I put it to them like this: do good, look good, and be good. Do good means produce, deliver a fair, efficient, just result in the cases before you. Look good is to be aware of what's happening in your cases so you don't read about yourself on the front page of the Miami Herald for having done something that in retrospect doesn't look as good as you would otherwise hope. And be good is to feel good about the job that you've done. My judges are under enormous stress. They each have about 6,000 cases. A regular caseload used to be 1,800. Our infrastructure in my civil courthouse, we're built for capacity of about 35 or 40,000 cases a year. In 2008, there were about 56,000 foreclosures filed. In 2009, it was around 77,000, I believe. So that's in the course of 2 years, 120,000 foreclosures filed. On top of that, we still have the car wrecks and the contracts and everything else that we do. So there are definitely morale issues. All of those have been compounded by recent revelations about robo-signers. Okay, let's start talking about robo-signers. It's not like any of the institutions came forward and said, oh, we've been such fools. We engaged in this. No, this all got revealed because borrowers who don't have any money for the most part and are pro se for most part, a couple of them went out and got attorneys who took depots. And in those depositions, this robo-signing process was revealed. Now, there's no way you can tell me that somebody that got past the 3rd grade at an institutional operation could not know that what they were doing was wrong by having people signing documents for filing in court that swore to the truth of certain numbers without even looking at the numbers and without being in the same room with the notary. There's just no, it just doesn't pass the straight face test, right? We've come to a place in our culture where it's okay to lie. In these cases, there is a lot of attorneys who have decided that it's okay to lie in court. It may be like the don't ask, don't tell policy, that if I don't look too far behind this document, I don't look too far behind this affidavit, then I don't have to confront the circumstances under which it was generated. We have a real issue with people's confidence and faith in the courts because we're foreclosing on the basis of these documents. For your judges, however, these represent very difficult philosophical issues because, look, we're the court. We're not an investigatory magistrate. We're not supposed to take sides. We're just supposed to rule on the matters before us. So how do we protect the integrity of the courts, and where do you fall down in terms of what you're willing to look at and what you're not willing to look at? I will tell you, I've tried death cases, I've done child sexual abuse cases. The ethical problems in dealing with these foreclosure cases are the densest I have ever dealt with. The civil division traditionally has not been an area where we had a lot of pro se litigation. The pro ses, they were all in family. Now there are very few defendants in foreclosure cases that can afford to hire an attorney. If they could afford to hire an attorney, they'd be paying their mortgage. So we have unrepresented people. How far do judges go in terms of advising them? Obviously, that's very limited. You have issues with regard to the presentation by the plaintiffs. You have defense attorneys out there as well who are doing things that are of questionable accuracy. I can tell you that my own philosophy that I've been working with and teaching in Florida is this. If you can look at it, if anybody can look at it and tell that it's bad, you need to call it what it is. I get assignments of mortgage all the time that will say, you know, X banking institution in Rancho Mirage, California hereby assigns this note and mortgage to B institution located in, you know, Edina, Minnesota, you know, this blank day, legal description, and underneath the notary block is in Florida. Now, how does that work? I mean, that to me just doesn't, a third grader would be going, what the Sam Hill is this? That's my test. If on its face I can tell that this does not look right, I reject it, I don't accept it. Now, there's no way that the court system is going to be able to catch the documents that Ms. Wills just created on her little handy-dandy Epsom. But there are issues that we can catch. In terms of how to support your judges in trying to protect the integrity of the system, I have 3 suggestions. Educate, standardize, and systematize. Educate, number 1, is make sure your judges know the peril that these files represent. What is required for a basic foreclosure? What is appropriate? What is the law that applies to these cases? For the most part, for many years, you didn't have to do an in-depth amount of legal research to do a foreclosure case. Those days are gone. These are now have become much more complicated cases. Even though a holder of a note is entitled to foreclose, the bottom line is your judges need to know at least what they ought to be looking for and what they ought to be looking at in a foreclosure case, and to understand what the downsides are. There are people lying at all levels of these cases. I've had 2 service processors in the past, process servers in the past 6 months in front of me who signed affidavits of service that said they individually served a defendant, were brought in on the stand, admitted that in fact they just left the documents at the front door. I mean, that is entirely unacceptable. It goes back to this. When did it get okay to lie? When did it get okay to lie in court? It's not, and when we find that, the courts have an obligation to take action, either by referring to a prosecuting attorney or to the bar or whatever the appropriate supervisory entity is. On standardize, I have 26 judges. I will tell you that after you get through the education piece, everybody wants to figure out a way to deal with this, because I honestly believe that all judges want to do is deliver a good justice product at the end of the day. So come to some consensus about how you want to approach these cases. In Miami-Dade County, we created an overall foreclosure master calendar. That's this brochure. We got 1 year's funding from the legislature to do this. That's gone now because nobody has any money. And we pre-screened every foreclosure case so that before you got to see a judge, because let's face it, the judge is your apex resource. That's the most expensive piece of your process. You don't need the judge being the paralegal for the foreclosure firms because they forget to put the papers together in a proper order or forget to show you service on a defendant or whatever. That can be done by lower level individuals who aren't quite as expensive. So we have pre-screening by trained case managers, and Mary Lee's going to cover that in a minute. We also had a system for writs. We had a possession to throw people out of their houses. We had a system for summary judgments. We have a system for trials. So we systematized across the board how each case was going to be handled. We took all our older cases and case managed them, and also in your packets is our initial case management conference and our second case management conference. If you're going to look at anything, look at the second case management order. It is a foreclosure colonoscopy. It has a list of every question that you could conceivably need to know or want to know about a foreclosure. Because sometimes you would have, you used to be able to rely on law firms. If they said it was there, it was there. If they said it said something, you could rely that it said something. That is not the case in these foreclosures. You can either decide that that's a product of greed, not going there, or you can decide it's a product of incompetence and having too much work. I don't know. But the bottom line is I have had firms submit an affidavit of non-service in support of a default. I have had firms submit an affidavit of non-military in support of a default that says in its face that the defendant is in the military. And I go look in the file, and sure enough, the guy's serving in Iraq, and they're sending me a non-military affidavit. But if you didn't fly spec that affidavit, it looks exactly like a proper non-military affidavit. So there's a need to go through these files with a fine-tooth comb. Most judges are not inclined to do that until they understand how grave a problem it is, and quite frankly, because I think a lot of people, judges and otherwise, are most responsive when their self-interest is at stake. I go, look, you don't want to read about yourself on the front page of a newspaper for foreclosing on somebody who's serving our country in Iraq. Now, and they don't want to foreclose on anybody who's serving our country in Iraq. They don't want to foreclose on anybody who shouldn't be foreclosed upon. So by standardizing everything across judges, you can avoid the problem that you get from the firms, well, Judge so-and-so doesn't require this, Judge so-and-so doesn't require that. Plus, patterns emerge much more quickly, and you can identify where the problems are and respond to those problems. So if you can get your judges, once they understand the scale and significance of the problem, to agree on an approach and absolutely maintain that across the board, you'll be much better than trying to leave the response to your individual judges. In Florida, each circuit got a certain amount of money to try and attack the backlog. Other circuits got criticized for having rocket dockets, so on and so forth. There was never a critical article published about Miami-Dade County. Part of that is because I talked to the media whenever and wherever and however they wanted to talk to me, and I would explain all the work that we were doing behind the scenes to try and make sure that everything was as it should be. But the other part of that was because we were very strict about compliance. The day we started reviewing summary judgment packets, we kicked back 30%. The day we finished, July 1st, 2011, we were still kicking back 30% because I can lead them to water, but I can't make them drink. But the bottom line is that screening procedure worked. And finally, by systematizing it and creating these standards from which you do not deviate and you do not give anybody a break, because we used to look and say, well, yeah, okay, this is good. This is fine. I can do this. When you require strict compliance with the rules and strict compliance with your standards, that systematization is the most likely to produce across-the-board improvement in the product that you receive and upon which your judges are going to make their decisions in deciding the cases. So educate, standardize, and systematize is the best bet. Because somebody asked me this at the end of the last session. It's coming back, folks. Right now, we're in a huge lull. 2 years ago, they were hauling files in on trolleys into my courthouse, 700 a day. Now, if we get 1,500, 2,000 a month, that's a lot. But it's coming back because you can look at the mortgage bankers' delinquency numbers, you can look at the shadow inventory out of there. There's a lot of people not paying for their houses. A lot of times there's a tendency to want to go to the moral judgment of, well, they're not paying for their houses, and so somebody's got a right to foreclose, so you know, it's okay, I can sign this judgment. Well, you know, the truth of the matter is, if you wrote a check to FP&L at Florida Power and Light, sorry, forget where I am, and somebody else went and cashed it, and Florida Power and Light came after you and said you still haven't paid your power bill, you'd be really upset at whoever cashed your check. Well, that's what we're being charged with preventing. We're supposed to make sure that whoever's foreclosing has the right to foreclose, that the note is endorsed to them. We get the note in 98% of the cases. Now, I can't always say that it's the original perfect signed note. I know more about that today than I did yesterday. But we get a note that we look at. We make sure it's either open endorsed or that it's endorsed to the party foreclosing. We go through the chain if there's more than one endorsement. We don't just sign off on this stuff anymore because the attorney hands it to us and says everything's in order. I encourage everybody to go through that step. Most states have a business model where a limited number, it moved from local firms doing foreclosure work to a limited number of statewide firms that were doing most of the work on a flat fee basis. Okay? The year I had 70,000, if you do the math on a $1,400 flat fee, that's something like, I don't know, $12 million in attorney's fees sloshing around my courthouse. The incentive to pay individual attention to any specific file is very limited. These cases are prepped at the institutions in an assembly line fashion and nobody takes responsibility. These cases are prepped at the plaintiff's level in an assembly line basis. Nobody takes responsibility. And in fact, in many situations, because if you go to a lawyer from a bus bench ad, that's what you get. And the defense side, there's standardized assembly line defenses that are not tailored to any case. And my message to the firms on both sides of this issue and to my judges is, look, this case has to be treated like every other case in the courthouse. We have to insist on compliance with the rules of civil procedure. Nobody slides, not on the plaintiffs, not on the defense. We have to make sure it's right. If they're moving for summary judgment, we have to make sure that they have met their burden of proof to prove that they win this case. So with that, I'm going to hand the mic over to Meryl Lee, who's going to give you an outline of just what our screening process was on summary judgments.
Hi, everybody. Basically, we wanted to, when we created this program that we had for a year, we basically wanted to safeguard the due process rights of litigants. And in order to do that, we needed to make sure that our paperwork was being done correctly. Hence, our checklist that we created for the program. This checklist, and before I start reading the checklist, I want to make it clear that we had basically 15 case managers reviewing over 500 cases a day that were being delivered to the program. In other words, we had 500...
Not a piece.
No, not a piece.
Not a piece.
Not a piece. A law firm would come and deliver 500 packets. And we had 15 case managers reviewing these every day, working tireless hours doing this. With that in mind, I'm going to start with the service of process.
It looks like this. It's in your material.
Well, not everybody has it. That's why I didn't say it. But the checklist looks like this. And if you don't have it in front of you, you have it in the CD that you were given, which you can actually look at later. The checklist has 7 elements to it. The first one is the service of process. And it's a very important element because let's say that one case could have 80 people on the service list. We needed to assure ourselves that everyone on the service list was served. We needed to assure that the individual, if it wasn't, an individual serve, it would be a substitutive serve, if not a publication serve. This is one of the things that our case managers would look at. And there's in this checklist, and the one that's there for you guys will be able to see what each thing means. Next, we went to the documents. The documents was an important piece for our case managers to review. They had to make sure that they had a copy of the mortgage. They had to make sure that they confirmed the proper address and description of the property, because in other states we had heard that they didn't have the proper address or the legal description. We wanted to make sure that that was there for our judges to review. And when I say review, these case managers were reviewing. They were not making decisions. They were basically taking the information that was being given to them and making sure that everything that the judges needed to look at to make a decision was there for them. With that in mind, we also made sure that we had the original note, any assignment of endorsements, and so on and so on. Let me go on to the next one. Number 3, mediation compliance. In Florida, if it was a case before May of 2009, it was not mandatory to have mediation. If it was over 2009, it was mandatory. So we needed to make sure that those documents were there as well. Affidavits in opposition to motion for summary judgment. This is where the attorneys could file any kind of rebuttal that they wanted and anything that they wanted to file. So that was there as well for the judge's review. And anything that our case managers found that was not right or iffy, they would flag it so that the judges could review it later on. As long as all the elements that we had requested were in the case packet, we would let it go through for the judge to review. When it would be rejected, it would be if everything that we requested was not in the packet. So if we requested for you to have a copy of the mortgage and it wasn't there, that was a rejection. And that would not go forward for the judge's review. Let's go on to motion for summary judgment, which is number 5. The motion for summary judgment, we just basically wanted basic elements. For example, when the motion of summary judgment was filed, because we had to make sure that they had given 20 days out in order for the defendants and the plaintiff and everyone to be notified. Proper parties, sometimes, again, I'm going to repeat, we had 80 to 100 persons on the service list in one particular case, and that we had to do the mailing for that. In any particular week, we could do 5,000 mailings. So that was a lot. Number 6, the affidavits. Basically, there were, the affidavits was to check for the unpaid principal and things like that. The affidavits of cost, which is the next section, which is section B, and you'll look at it when you're able to look at it, was where we were able to check the interest on the property, because you're only able to file interest until the property is in default. Whether, for example, the process server, how much did the process server charge to go out and serve? Because if you had 4 people on the service list, you could charge at the most $50 per person. We had cases where they charged a lot more, so they were flagged. Affidavits of attorney's fees. This was a really interesting thing for us, because to us, a regular case would be $1,300, $1,500. In particular cases that were very high litigated, it could be $1,800. We had attorneys that charged $22,000, $18,000 for court cost. So when those kind of things were seen by our case managers, they would flag it for the judges, and the judges would then address that on the day of court. Additional counts, again, the legal description is important that it would be in there. Any omitted parties as well in a voluntary dismissal, or if they were not warranted any longer to the case, would also be important. Judge, I know you're looking at it, so I know you want to add some things to it.
Well, let me add a couple of things. The case, as Marilee said, they kicked back for things that were missing because, as I said, your judge is your apex resource. So every time you want to have a case see a judge, you want something to happen. You don't want it to be a non-event because some proof of service is missing out of the packet. They would then flag it in the comment section and say, for example, in Florida, there's this huge habit of filing 4 returns of service for unknown tenants, even if it's owner-occupied. Well, they were charged $110 a piece for unknown tenants. They serve the owner, and then they charge $110 for these unknown tenants that were unknown because they didn't exist. Those kinds of things would get flagged. If they were trying to reform the deed because the underlying property transfer had some issues with it, you have to serve both parties to the deed in the lawsuit. If those parties were not part of the lawsuit, and that this happens all the time, they could not reform the deed. That would be flagged for the court. Again, what part of this is to try and avoid these cases all coming back as title cases in a couple of years. So if there was an issue, it would be flagged and it would be made available to the judge for review. And the judge would be in a position to evaluate a rule on it, but it would give the judge a heads up without the judge having to spend a half an hour going through each file with a fine-tooth comb. One final thing, I didn't touch on this today, but I'd like to touch on it with the rest of you. Overall, across the country, our funding entities, which is usually our legislatures, are becoming increasingly interested in performance-based accountability. And performance-based accountability is in and of itself not a bad thing, but it is hard to measure justice. And one of the things that I would urge everyone to also look at, if you are being measured on standards such as number of cases closed, et cetera, is really look at the accuracy with which your cases are being closed. In these multiple defendant cases, and 80 was a high point, but let me tell you, in Miami, if you have a defendant named Juan Garcia, you're going to have 100 defendants' names because they're naming every defendant that has a judgment against a guy named Juan Garcia. You need to make sure that your clerks are getting those cases properly closed, because those are the counts that are going to go to your legislature and upon which your judges are going to be judged in terms of efficiency. No judge should ever be so concerned with a case count that they close cases in a manner that is unjust. But if you do the work and the case is appropriate for resolution and you rule and resolve the case, then that case should be closed. And that's one of the things that we've uncovered during this process, is you want to make sure that you also, in the systematized piece, have good, solid accountability. There's a ton of stories in foreclosure world, but you really can't make systematic, appropriate decisions based on anecdotes. Everybody's got a story. You need to look at the numbers and figure out what works and what doesn't work. As we devised this system, we had charrettes. We invited everybody we could identify who is a stakeholder. We have an email list of over probably 140 different firms that we know do foreclosures. We have town hall meetings. We've had conference calls, like those open conference calls. 2 weeks ago, we ran a day-long seminar on how to get your foreclosure through the 11th Circuit. So it's not just the judges dictating. We're trying to hear from the firms on both sides of this as well and be responsive to their needs. But the bottom line is, right now we're in a lull. The institutional plaintiffs have got things on hold because of the scandal over documents, the Office of the Comptroller of Currency, the 50 attorneys generals that are looking at them. But they're going to come back, because if you're a judicial foreclosure state or you're a non-judicial with just some sort of judicial relief valve, the bottom line is that ultimately these cases are going to have to be resolved for our country to move forward economically. It's our job to do it fairly and appropriately and justly under the circumstances, and try and make sure that at the end of this, people have as much faith in the court system as they did the day before this all started. So with that.
And one final thing that we didn't touch upon before, and maybe Judge Bailey can add to that, bankruptcies. We found that there were many cases coming before us where the attorneys would say this case is in bankruptcy. When we looked at the paperwork and when we checked on PACER, which is a way that you can check whether the case is on bankruptcy or not, a lot of these cases had already been closed. The case had been ready to foreclose for a while, but the attorneys kept saying, no, the case is in bankruptcy. So it's important to tell your judges to look at that. Don't take it for granted that, the attorney's telling you the case is in bankruptcy, because the case might have already been closed. Judge?
I think that fairly summarizes the approach, which is, I don't want to say that any plaintiff's firm or any defense firm is is diabolical, all right? I mean, we've had implosions of firms in Miami that have been spectacular and splashed across the headlines of newspapers across the country. But the bottom line is, with these cases now, your byword should be trust but verify, because the volume is such that the reliability that traditionally applied to filings in courts of law by officers of court is not what it once was.
Thank you. Suzanne?
Thank you. If I may just add a couple of other things, too. In Maryland, we responded, or the judiciary responded, by passing an emergency rule that allowed for this very screening of foreclosure cases, but it also provided for the ability to issue what we call deficiency notices contemplating dismissal if a deficiency that is found in the screening process isn't cured within 30 days. That has helped tremendously to increase the integrity of the filings that have come in. We did see a very large dismissal rate as we began doing that. The other part of the rule really does address, though, the problem of what happens when you have affidavits that look fine on their face until you find out that the person who was purported to have signed it didn't actually sign them. And so the rule also provides that we're able to have show cause hearings in which the people who claim to have signed these documents and done so in compliance with the rules are brought in, and they are examined under penalty of perjury, and they must swear under penalty of perjury that they did indeed sign them. We have had almost 100 of these hearings at this point, and the results have been pretty stunning. People walk in and say that they did not sign them, did not review the documents, but trusted the person who did, and therefore are adopting that signature as their own. That has not gone very far. We have notaries come in and acknowledge that they did notarize documents without anybody being present, and sometimes they forgot to even have somebody sign those documents to begin with. Every one of these people who comes before a special master who conducts these hearings is apprised of their right against self-incrimination, but they do not seem to understand that what they are testifying to is behavior that is, at best unethical and possibly even criminal. We did find in looking at these cases that there was a belief out there that if the court didn't demand it, they didn't need to comply with the rules. And we saw case after case, not just within the foreclosure filings, but also within the general civil, and even in the criminal filings, in which there were multiple signature lines with a single illegible signature. So it was never clear who among the 7 or 8 people who were signatories actually did sign this. And so it became apparent to the administrative judge that what needed to happen was there needed to be a general call back to rigor in applying the rules, rigor in enforcing the rules. And so in Montgomery County, Maryland, there were announcements made that if pleadings were not filed in compliance with the rules, that if there was not a single legible signature along with a single signatory, that those pleadings would not be accepted. And that has gone a long way to send the signal that the old way of assuming things could be relied upon is gone. The need to be able to hold whoever has filed something accountable by virtue of being able to identify who they are has sent a pretty strong signal out into the jurisdiction that Montgomery County insists on rigor in its pleadings, and there will be integrity or there will be accountability. And while we may be fooled some of the time, at this point, the cases where there is a notarization but no signature, there is a gentleman who, when he signs documents in Towson, Maryland, signs them completely differently than when he signs them in Baltimore, Maryland. Those people are on notice. They've been brought before the special master. They know that their cases are going to be dismissed and that there may be additional consequences that they face. So with that said, I would before we go to questions, I would be very remiss in not noting that this panel was made possible through the support of the Bureau of Justice Assistance and through the American University in Washington. And before we go to questions, I did want to acknowledge that. So if there are questions, I think the panel's happy to answer them. Yes, sir.
I'm Norman Meyer, and I'm a clerk of a bankruptcy court in New Mexico. And so you're mentioning and checking the bankruptcy as part of your process, which we of course. But my question is, from the state court perspective, of course, you handle foreclosures. Are you getting adequate information from us on the bankruptcy side? Is there a need for better cooperation or anything like that that we in the federal courts can handle the bankruptcy matters can do to collaborate better to help you in the state courts?
Just one second. I've been asked to repeat the question, and the question is are the state courts getting enough information that they need from the federal bankruptcy courts, and is there a need for additional cooperation?
The answer in Miami would be, you're right across the street, and we eat lunch with you a lot. So we have a great relationship with our bankruptcy judges, and when we spotted the problem, they immediately hooked us up and gave us access into PACER. So any judge can pick up the phone, call the staff member with PACER access, and check a bankruptcy right away. And what Marilyn said is absolutely true, and this is the kind of don't ask, don't tell misrepresentations that we get. We'll have a case come up on a lack of prosecution calendar, and the lawyer for the plaintiff will come in and say, well, Judge, this case is in bankruptcy. And I'll look down and see, I say, well, when was the bankruptcy filed? And they go, 2008. Well, I'm pretty sure if it's a 2008 bankruptcy, they're done one way or another. And so, unless it was a really extraordinary estate.
Could be a 13.
Could be a 13. But, not a lot of those. So, but I'll check. I say, okay, well, let me check with PACER. And it will turn out that, they didn't even file the initial schedules and it got dismissed before the end of the year. Or that they've been through it and they're discharged. And so I can say to the attorneys that are appearing before us have a singular problem of not taking responsibility for the files. It's like they're there to cover this one hearing, and all they need to know is this one piece of information that they need for this one hearing. And it's very difficult for your justice product because we're there. We want to say, okay, so look, what's going to happen with this file? Where are you at in your summary judgment? Where are you at with your affidavits? And the answer to that is, and so we're, trying to go back to instill this better sense of responsibility. Where people are in bankruptcy stay, the only other problem is they don't always tell us, and we end up having to vacate final judgments. But we try and be responsive and, of course, respectful of the automatic stay provisions, and we try and say to people, let us know if you're going into bankruptcy. Are there any other questions, or have we stunned you all with our breadth of knowledge? Yes, sir.
You talked about going through the checklist and rejecting certain cases because something wasn't there.
Mm-hmm.
What does that mean to reject it?
Well,
what happens to it?
Thank you.
Let me just repeat the question. The question was, in going through a checklist and rejecting a case, what does it mean to reject a case and what happens to it then?
Well, reject the case means that we're there to collect the appropriate documentation to give to the judge to look at. What we do is, if something that we requested on our checklist is not there, and it could be as simple as envelopes for the mailing, because when you add it up, if you're doing 5,000 pieces of mail a week, it adds up. So we had the firms give us the envelopes. Something as simple as that would reject the packet if it wasn't there, and we would give the firms opportunity to bring us what's missing. That would then go back to the law firms, or we would wait 24 hours, I think it was, that we gave them to give us what was missing. If not, they would have to come and get their packets and resubmit them when they had all of the proper documentation there.
We would email them with that, though.
Right.
When they submitted their packets, we'd get an email. We'd send them back an email saying, look, you're missing your envelopes and you're missing proof of service on defendant 24, State Farm, Mutual Insurance Company. You've got, and we wouldn't hold them indefinitely. We started out holding them indefinitely, and that turned into giant stacks of paperwork all over the place.
Hundreds.
So then we said, okay, you have 48 hours to get it to us. And if not, we are putting, we're throwing your packet back into the bin, because each firm, there were a limited number of firms, each firm had, a bin. If they didn't come get it out of their bin, after a while, we'd throw out the bin. We did not have them submit to us the original note. We only got a copy
Copies
of the
of
note.
everything.
We were very strong about don't file or give to us the original note bring it to the hearing. And the reason for that, among other reasons, is there are so many of these things that when they were getting filed into the court files, they were getting lost, they were getting misfiled. And secondly, if it's an open endorsed note, it's like a bearer bond or a check made for cash. And we don't have the resources to, monitor everybody that looks at court files. They're public documents. So somebody could come into a court file and simply remove the note. So we said, don't file and bring them to the original, bring the original to the hearing, just file an accurate copy. Now, when you went into, where you got into problems with that was when the copy they would give you was not endorsed, and all of a sudden the original that showed up at hearing was endorsed, which happened a lot.
A lot.
Or where, and I mentioned this morning and I forgot to mention, one of the things that we did as a result of the foreclosure task force, because there was so much question about the standing issues and who actually owned these notes, is we passed a rule that the Florida Supreme Court adopted that complaints per foreclosure had to be verified. Well, our foreclosure filings have fallen off a cliff this year. Some people speculate that it's the robo-signer. Some people speculate it's not wanting to take the properties. But there is a whole lot of word on the street that it's because we're requiring verification and nobody wants to put their John Hancock at the end of the complaint on behalf of the institutions and swear that the contents of that complaint are true and accurate. And if that's the case, then we have done a good job, because if they can't swear to the contents of the complaint, they shouldn't be foreclosing. That's not, but let me add also on the flip side, I've been in this up to my eyeballs for 2.5 years. I've never had a borrower come in and said, I have religiously paid my mortgage, I'm not in default, and this whole thing is a huge mistake. So, there's problems on both sides of this. The problem is, these are simple cases. Notwithstanding the complexity of securitization, if you are honest, if you have the documents, it generally takes one hearing. You go out, you file your complaint, you get it served. Whatever the answer is or the default is, it is. You come forward on summary judgment with reliable and accurate affidavits. You win, you lose. If you lose, you set it for trial. And it's a 2-witness case, tops, maybe 3. These are not difficult cases. They're being made difficult by the inattention and lack of attention to detail by which they are being handled on the plaintiff's side and on the defense side. So in order to protect the integrity of the court system, we need to insist that both sides comply with the rules, comply with the law of evidence, and do it right. It's not that hard. Anybody else after that rant? Suzanne?
Well, thank you all for coming. Please enjoy the rest of your conference. Some of you have received hard copies. There are DVD or CD versions of the materials. It will also be posted on the website. Thank you again, and I'm sure any of us will be happy to answer questions as you go home and you think about what you may be confronting in your courthouses. Thank you.
Thank you.